Oh yeah, all bad guys. All bad guys. One of them done? Yeah. One guy. One guy in charge of
Because they came started with it. And yet they were the ones that started. Came up with going through the guns, the guns. 9:55.
Everybody rise, please. Please be seated. Court will come to order.
Bring a jury on in, Mr. White.
Ladies and gentlemen of the jury, please take your seats in the jury box. Take your original seats. Present, sir.
Now the prior stipulation, polling is waived and presence is noted. You may proceed, Mr.
Ladies and gentlemen of the jury, before I begin my comments to you concerning the evidence, lack of evidence, as I see in this case, I'd like to thank you for participating in this trial and let you know that we appreciate you being here. This has been a long case and an important case. You all have made many sacrifices to be here, to sit with us on this jury. You know that you've come away from your homes and your families and your businesses and your retirement. And know that you've done this not only to fulfill your civic duties, but to see that justice is properly done and that our courts system is properly administered. The defense does not deny there was a great and horrible tragedy that occurred in Tallahassee on January 15th. It's true that these poor, unfortunate women were beaten while sleeping in their beds and injured and killed. But I ask you not to compound that tragedy with convicting the wrong man, where the state's evidence is insufficient to prove beyond a reasonable doubt that Mr. Bundy and no one else is the person that committed these crimes. Defense contends that the state's evidence in this case does not live up to its burden. Evidence required of the state to prove guilt beyond a reasonable doubt does not contemplate possibilities, or speculation, or belief, or conjecture. Our system of justice is founded upon the principles that an accused is presumed innocent unless and until the state takes away that presumption of innocence by proof beyond into the exclusion of every reasonable doubt. Mr. Bundy doesn't have to prove anything in this trial. The burden of proof is solely upon the state. The presumption of innocence is one of the valuable features of our system of justice. And that's one of the reasons that you are here as a jury, to determine whether or not the state can meet their burden in this case, and whether or not the proof has been found to be sufficient. When our forefathers founded this country, they were running away from a totalitarian system. They were running away from a place where a person was assumed to be guilty until he proved that he was innocent. That is not the system that we operate under here. Our system presumes that Mr. Bundy is innocent, and it is solely up to the state to remove that presumption of innocence if it can be done. How tragic it would be if a man's life could be taken from him because 12 people thought that he was probably guilty, but they were not sure. The law requires, and it is your sworn duty as jurors, that until the state has shown you that their proof is proof beyond a reasonable doubt, that no conviction could be entered in this case. If there are any doubts that sounds reasonable to you, then my client Ted Bundy must be acquitted. He must be given the benefit of the doubt, and you must render a verdict of not guilty in this case. This is a serious decision that you are asked to contemplate and deliberate and go over with your fellow jurors. I would ask you to give the same kind of important consideration to this case that you would give to any other kind of important decision in your life, such as whether to buy a home, whether to marry or divorce, or whether to have children, because this is a serious decision. Ask yourself, after you go back there to deliberate and you discuss it among yourselves, does the state's evidence leave me with an abiding conviction of guilt, to a moral certainty that Mr. Bundy and no one else committed these crimes? Or does it leave you with a thought that vacillates and you are unsure as to whether or not the proof is sufficient? Only if you are so convinced, with an abiding conviction of guilt, could you find Mr. Bundy guilty. Otherwise, if you are not morally certain, if you are unsure, you must acquit him. Lord Elton once said, "I have always thought it better to allow myself to doubt before I decided than to expose myself to the misery after I had decided of doubting whether I had decided rightly and justly." Otherwise stated, and as applied very practically to the decision which you are about to contemplate and undertake, is that you must assure yourself that you will not wake up and doubt your decision and wonder if you convicted the wrong man here 2 weeks after he is dead and gone. If you are not sure, if you have reservations, if you feel that the prosecution has not supplied that missing link in the chain of circumstantial evidence, or if you feel that one of the links in the state's case of circumstantial evidence is weak and is not only consistent with an interpretation of guilt, if their circumstances are also consistent with an interpretation of innocence, then you must accept that interpretation which points to innocence. That is the instruction the judge will give you. I would ask you to listen carefully to the judge's instructions and to apply them to the facts of this case. If you feel that the missing links or the weak links are not proven, then you must give my client Ted Bundy the benefit of the doubt and find him not guilty. That is what reasonable doubt is all about. Unlike Mr. Simpson, I haven't had any experience in speaking like this, so I will have to speak from notes, and I hope you'll excuse me, but all the same, there are many reasonable doubts that arise from the evidence in this case that I want to discuss with you. The first area of reasonable doubt, the first problem with the state's evidence, is the quality of the evidence, is the manner in which the police conducted this investigation in the first place. Some people may not want to admit it, but the police can and do make mistakes. There are basically two ways for the police to investigate a crime. They can go to the crime scene. They can look for the clues. They can follow the clues to their logical conclusion to find the suspect. Or they can find the suspect decide on a suspect and decide to make the evidence fit the suspect and work to make the evidence fit only him. It is a horrible thing that has happened in Tallahassee. But you can't convict the wrong man because the police have ignored the clues and because the police have failed to investigate this case properly. Particularly, is the police mistakes are evidence, the mistakes are evident from the evidence that they ignored and the evidence they didn't follow up on, such as the fingerprint evidence and such as the serology evidence which the defense presented to you, which shows a positive exclusion of Mr. Bundy, and I'll discuss that with you a little later. If you look at the way the police arrived at the crime scene, remember how the officers all testified in some of the sorority sisters to the initial disorder, the mass confusion of 15 officers going into Dunwoody scene, of 3 different departments, Florida State University police officers, the Leon County Sheriff's Department, the Tallahassee Police Department, all going in. About 10, 15 people went into Margaret Bowman's room to see where she lay. And it's interesting for you to remember and recall the sequence of proof here. How the state presented the evidence that they managed to save from the crime scene. The first day of this trial, you heard multiple descriptions of the horror that the person saw when they arrived at the crime scene. Second day, they showed you multiple photographs of the beds of the victims and the blood that was found on the bed sheets. On the third day, they introduced piles of bed sheets and pillows and nightclothes and pillowcases. And their serology testimony to show what was completely obvious, what no one would have thought to question from the first day, which was that the blood of the victims was the blood that was found on the beds where they were lying when they were beaten. Would suggest to you that the only reason that the state presented all of this cumulative and horrible evidence of the blood at the crime scene and all of these tangible items of evidence was to prejudice you and to cloud your emotions to your assessment of the scant evidence concerning Mr. Bundy that would follow. You should consider what it was that the police forgot to do, what they overlooked. There was testimony concerning a Clairol bottle found in Lisa Levy's room, which seemed to appear to be a valuable piece of evidence. Somebody said it had some hair elements on it, had some blood on it. It might have been used as an object by the perpetrator of these crimes, and any fingerprint evidence on this item was also lost. It was kicked around on the floor for 5 days. It was not collected, and it was not properly preserved. They show you a picture of a woodpile out back. They take no cast prints from around the woodpile. They gave you no photographs of the foyer, only a description from one of the witnesses that this was a bright wallpaper. I ask you to look at the pictures that we've introduced into evidence, and you'll see that's not bright wallpaper. That is dull and dim, dark blue. A very dark room. Also, consider the evidence of the pantyhose mask from Dunwoody that was spread on the floor, that was later swept, and you saw Ms. Lasko bring in all of those piles of hairs that were swept from the floor. There's no way that the state's circumstantial evidence of hairs on a mask shows you beyond a reasonable doubt that those hairs had to have been left by the person that left the mask. It's equally consistent with the interpretation that those hairs adhered to the mask when it was placed on the floor for purposes of photography. No officer noted what lights were on in the foyer that night. No officers tested the lights, the decibel of the lights, how the lights would reflect in that dark first room of the foyer. Nancy Dowdy did testify that when she went downstairs with Nita Neary that the light was subdued and that it was dim. It would be an important consideration for you to evaluate this evidence to know exactly what the lights were, but they forgot to find that evidence. They forgot to preserve it for you to know about. Another important piece of evidence that Officer Brannon discussed was in Margaret Bowman's room. He saw a pantyhose wrapper in the trash can. No one collected that evidence. No one attempted to take any fingerprints from that evidence. It's lost, it's gone. Who the assailant was, whether he had touched it, that is evidence you don't know because the police didn't bother to bring it in here and show it to you. It took no saliva smear from the bruise mark that they discovered on Lisa Levy at the morgue. There was no attempt at the morgue to lift any types of latent fingerprints from the bodies of the victims. They didn't even dust the exit point at the Chi Omega house when Nita Neary saw the man walk out the door for fingerprints either. And it's really too bad. You know, they did not show these lineups to these young women right away. They waited 2 months to show a lineup to Nita Neary, even though they showed one to Officer Dawes practically overnight after Mr. Bundy was arrested and they had a picture of him. They don't show a lineup to Carla Black for 5 months, to Connie Hastings for 5 months, and they wait 9 months until October to show a photographic lineup to Carla Black. It's too bad that they didn't show those photographic lineups before those young women saw Mr. Bundy's picture in the paper, because only then would you really be able to know whether or not they were influenced by having become familiar with Mr. Bundy's features from having seen his picture in the newspaper. The real way in this case to see how the police worked with the evidence to fit the evidence that they had into Mr. Bundy is seen by what they ignored, what they left uninvestigated after Mr. Bundy was arrested. There were numerous unidentified latent fingerprints found at both the Dunwoody scene and the Chi Omega house. There were about 260 persons that were placed on the officers' elimination list. Elimination lists were names of all those people that had some sort of access, lawful access to the premises, so that they could eliminate whether or not their fingerprints made the questioned fingerprints that the police were trying to identify with the assailant. All of the police officers, all of the residents, all of the known guests, all of the medical personnel, all of the waiters and the known house employees were placed on that elimination list. 260 persons. But those fingerprints remain unidentified. Now, before Mr. Bundy was arrested, they submitted to the crime lab names of 102 suspects in this case. But after Mr. Bundy was arrested, they only submitted the fingerprints of 4 individuals. They stopped looking. They stopped trying to find out who left those latent fingerprints at the Chi Omega house. And instead, they want to imply that somehow the assailant was wearing gloves. But there are pieces of evidence in this case that indicate to you clearly that that is not the case, that the assailant was not wearing gloves. First of all, the evidence technicians testified that they found no glove smears or fabric prints at the scene. Also, one of the very first people in Margaret Bowman's room found a bloody fingerprint on the edge of the door. Margaret Bowman didn't make that fingerprint. She didn't get up out of that bed after she was hit. But the evidence technician, the comparison man that came from the lab later, he looked at that bloody fingerprint and said that it had ridge detail, meaning the pattern of the ridges that are left by your fingers when you touch a surface, but insufficient detail for comparison purposes. That indicates that the assailant was not wearing gloves, and he left that ridge detail there on the door. And even though they can't identify that one print, They should still have kept looking to see if they couldn't identify all those other prints that they found, that they couldn't identify with any of their 260 elimination personalities. Furthermore, Nita Neary, who was looking at the man's hands more than anything else, said the man at the door wasn't wearing gloves. Said she was absolutely sure the man wasn't wearing gloves. And yet, there are places where the assailant would have had to pass through where there are numerous fingerprints that remain unidentified. Room 8, Karen Chandler and Kathy Kleiner's room, there were 11 points around the door jamb that were unidentified. There was one print in Margaret Bowman's room, and there were 2 prints at what they think, or what they want to call the point of entry, that remain unidentified. The police work alone in this case raises important questions and shows you reasonable doubts as to the force of the proof the state has brought before you. Now, the state has tried to indicate to you, in reference to statements made by Palumbo and Gage and what they think they heard the defendant say in this case, that perhaps he was smart enough not to leave any evidence, that whoever committed these crimes didn't leave any evidence. Look at the circumstances of the crime. Decide whether you think that these crimes are consistent with that hypothesis. Decide whether the evidence of how the person left in a rush at the scene at Dunwoody, knocking over plants and running out a window, where they find no glove prints, where they find no wipe marks. Decide whether that shows what the state is trying to turn it around to make you think it shows. After ignoring certain evidence, after failing to preserve other evidence, after failing to follow up the leads of the fingerprints that remain unidentified and cannot and are not identified with Mr. Bundy, without trying to find out who the real suspect is, the state is left with 2 pieces of evidence in this case that they had to fit to Mr. Bundy to make any case at all. And what the state's case boils down to is Nita Neary and the dental evidence. Clearly, both of these pieces of evidence, or the lack of evidence as to these 2 items, show a reasonable doubt in the state's case. As to Nita Neary's testimony, the real problems and the reasonable doubts that arise from her testimony stem from the very limited conditions for observation. The reasonable doubt as to her testimony is based on the fact that she didn't have sufficient opportunity to observe anyone to later make any kind of reliable identification. Consider what she said about her opportunity to observe. The man was about 16 feet away from her, going out the door. When she saw him, his left hand was already on the doorknob, and she saw him in an instant. The most she would estimate was 3 seconds. Better than that, she says, an instant. He was in a hurry. He was going out the door. And she saw a profile. The prosecution would have you believe that she saw a complete face. But even Nita Neary, in describing what she did to get those sketches, said, his head was down. I didn't see his eyes. I didn't see his eyebrows. Didn't see a jawline. What she says under hypnosis, what I remember is his nose. The state would have you believe that a protruding nose is a very distinctive feature. Well, it is the nature of a nose to protrude from your face. If your nose didn't protrude, your glasses wouldn't stay on. All noses in profile protrude. That is not very remarkable. That is not very distinguishing. That doesn't describe one nose to the exclusion of another nose, or all noses. You can't identify a person's face by one feature. Nita Neary gave you a better description of what she saw in that man's hand than she gave to his face. She described the color, size, the shape, that something was wrapped around it. She also gives you a clothing description of the hat, the knit hat, the jacket, the light pants. And a nose. She saw a nose. And what did she say? Prosecution would have you believe that when she saw the man at the door, she thought of a name. She didn't think of a name. She thought of a face. She thought of Ronnie Ng. Under hypnosis, she said the first thing she thought of when she saw that man at the door was Ronnie Ng. Her testimony at trial is, I didn't think of Ronnie Ng until I was going up the stairs. She thought of Ronnie Ng so much, she discussed it immediately with Nancy Dowdy. She told Nancy Dowdy she compared the man to Ronnie Ng. Now, Nancy Dowdy came in here and testified that when Nita Neary came up the stairs and told her about the man, that Nita Neary said the man was bigger or taller than Ronnie Ng. But at the time she talked to Investigator Hicks, 1 week after Nita Neary made that statement to her about Ronnie Ng, what did she say? She said the man was small. She compared him to Ronnie Ng. She was about his height. The next problem, the next real reasonable doubt about Nita Neary's testimony comes from that hypnosis session, where she committed herself to the standard that the man looked like Ronnie Ng. She committed herself as strongly to the similarity between the man at the door and Ronnie Ng in that hypnosis session as she committed herself, or would say, when she first looked at Mr. Bundy's picture in that photographic lineup. She said that there is a strong similarity to Ronnie Ng. She said that if you find a profile of Ronnie Ng, that would be a good thing to go on. We brought Ronnie Ng in here. We had Ronnie Ng stand up here next to Mr. Bundy. And so you could see for yourself that Mr. Bundy and Ronnie Ng don't look a thing alike. My client is significantly taller than Ronnie Ng. Ronnie Ng is 5 foot 8 inches tall, the same height that Nita Neary said was the height of the man she saw at the door. Ronnie Ng has a dark complexion, the same thing she said about the man at the door under hypnosis, and what she said to Officer Brandon. Court, she said a slightly dark complexion. And maybe that has to do with seeing the pale Mr. Bundy sitting over there. That man's complexion isn't dark. It's not even slightly dark. The description that Nita Neary gave to the police was so vague. In the words of Officer Crew, it was so broad, the police thought she was describing a light-skinned black male. Now, Crew would attempt to tell you by his testimony that he takes full responsibility. He was the one that was responsible for inserting the light-skinned black male into the description, that he put it out on a bolo. He wasn't the only one. He wasn't the only one that was looking for a black male as well that would fit. The fingerprints, the suspects they submitted to the lab, 17 of those individuals were black men. 17 of those people that they sent the prints to the lab to try and see if they were in the Chi Omega house were black people. And lucky for them, or God help them if any of them had crooked teeth. Next, the next reasonable doubt about Nita Neary's testimony are these newspaper photographs she saw. And she got up here and she testified, oh, I really don't remember, I really didn't look at them, I'm not really sure, I can't really remember. But we brought you in a tape recording of a conversation she had with Detective Bodiford on March the 14th, 1978. 1 month after Mr. Bundy's arrest, still hasn't been shown a lineup. And what does Bodiford tell her? We have a man in custody. You seen any pictures of this man we have in custody? And she says, well, I've seen pictures, 6 pictures. And 2 days ago, my mother showed me a picture that was sort of a profile. Part of a profile, half of a profile. And the nose did the best for me in that picture. She's trying to make it fit Mr. Bundy, but she's not sure yet. She doesn't know yet. They haven't made her make it fit Mr. Bundy yet. And they warn her, don't count him out yet. Don't count him out by what you've seen in the paper. And then they tell her to not look at pictures of Mr. Bundy in the paper anymore. And what does she say? Oh, you want me to stop? Is that the statement of someone that's just casually looked at a picture in a paper? That's a statement of a person that's been looking at his picture, that's been trying to see if it fits. Next reasonable doubt as to Nita Neary's testimony is Captain Pottinger's lineup. Waited several months, 2 months after Mr. Bundy's arrest before he showed that photographic lineup to Nita Neary. And how does he show her the lineup? What suggestive things does he say to her to make sure that she's going to fit it with Mr. Bundy? Twice before he ever shows her the profiles, he says, you know about the prime suspect? He so much as tells her that that prime suspect is in that lineup, and they sure do hope that she can pick it out. She already knows they need her testimony. She's already said to Bodiford on the telephone, well, I want to help you if I can, and if you think I can help you, you call me. Not that she has any information that she knows of on her own, but if they come to her and tell her she can help, then she'll help them out. And what's Mr. Bundy wearing in that lineup? He's wearing dark clothing. Look at that lineup. The lineup's in evidence. Compare the people that were in that same lineup. Look at their complexions. Look at their ages. Look at the clothing they're wearing. And then, before she says anything about anyone in the lineup, and this is on the tape, she holds out a photograph in her hand, and Pottinger says, oh, does that resemble the man? You're holding out one photograph in your hand. But even then she didn't say that that was the man. She looked through them again, and she picked out 2 photographs, number 4 and number 7. And she's still not sure. She says, well, number 4, it fits closest. But he wants to make her sure. He says, is that the man? Or is that a definite resemblance to the man? And her statement was, I don't know. Pretty definite resemblance. And now she doesn't even know, she can't even recall, she doesn't want to remember that she said, I don't know. She wants you to believe her opinion that she's sure. The circumstances surrounding how she got to that opinion, her first times that she saw Mr. Bundy's picture on paper, the first time of seeing the photographic lineup, she wasn't sure. She wasn't even sure when she saw Mr. Bundy in the courtroom in October in Tallahassee. That time she still says, well, it looks like the man. She's still not sure. What does she tell Bodiford on the phone? Well, going back to this profile stuff, well, she can't identify him unless she sees a profile. She only saw a profile. And that's what she tells Pottinger. But you saw her sit here. She pointed across the room and pointed out Mr. Bundy. Full face. She knows who Mr. Bundy is. She didn't have to see a profile. She identifies the full face. Basically, Nita Neary has been caught up in a terrible situation. And she wants to help if she can. And she can't let herself believe that the man that committed these crimes is still out on the streets. So she can now let herself be sure, after all the uncertainty, and she can let it fit to make it be Mr. Bundy. I want you to think about Ms. Neary's testimony. Think about the circumstances under which she said she saw this man. Think about if Nita Neary came to you and said, I saw your spouse leaving the motel room with another person.
Objection.
Abstain.
Ask yourself if that's the kind of testimony that you would base an important decision upon. Next, the state tells you that Mr. Bundy, I want you to believe that Mr. Bundy was in charades because of the testimony of Connie Hastings and Carla Black. And these two young women went to a crowded bar with a group of their girlfriends. And they observed an unusual man who was looking at them. And I think we all have admitted by now that it's not unusual for men to look at women. And I'd also like you to consider whether or not it's unusual for someone to be so unnerved or conscious that a man is staring at them. They remember his face for 5 months in the case of Connie Hastings, and for 9 months in the case of Carla Black, with absolutely no sense of recognition when they see Mr. Bundy's picture in the paper. Both of them had seen Mr. Bundy's picture before they looked at a lineup. But what is most incredible about these two ladies, what is most incredible and what shows a reasonable doubt as to both of their identifications, is that they gave you two completely and totally different descriptions of what the individual in charades looked like that they're now going to try and make fit Mr. Bundy. Hastings said that this man was wearing clothing which was completely different from Carla Black's description. He was wearing dark clothing, old suit jacket, with a dark turtleneck sweater, short brown hair, a little longer than a marine cut. In an original description given to Officer Sanders, she states the man had a rough face with acne scars. Carla Black, on the other hand, sees a man in a blue baseball jacket with a light button-down shirt. Light button-down shirt, not a black turtleneck, a light button-down shirt. Dark hair that's slicked back, greasy, down to his head. And what they have given you are two completely different descriptions. But yet they both purport to say that these two completely different men was Mr. Bundy. Look at the circumstances under which they made these so-called identifications from these photographic lineups. Phillips is told by the prosecution 5 months later to go see if he can get an identification. And what does he tell her before he shows her the lineup? See if you can pick out the man that was in charades. That suggests that the man that was in charades was in that photographic lineup. She's already seen pictures of Mr. Bundy in the paper. No sense of recognition. Gets to Mr. Bundy's picture in the lineup. First she says, well, he was the only one in dark clothing, and the dark clothes helped me make the identification. And then she says she knew it was Mr. Bundy before she picked it out as the man she saw in charades. Completely contradictory to the testimony she had about seeing those pictures in the paper. And still she only says, well, I think this is the man. But Phillips, he testified out for his investigative purposes. That's no good. He doesn't want an unsure witness. So he asked her to be sure, to make it fit. And then he doesn't even want to tell you that he told her, or that she told him, that she knew that picture was Mr. Bundy. As soon as she identified it, she said she told him, is this a picture of Mr. Bundy? And he said yes. Carla Black is not much different. She too saw pictures of Mr. Bundy. She saw him in the newspaper. She never called up the police and said, "That's the man I saw in charades on the night of January 14th." You don't remember the face of a man that stared at you in a dark, crowded bar for 9 months and then base the fact that you can identify him from his eyes up. But you can't identify anything from the eyes down. Only from the eyes up. That forehead, it's that distinctive forehead, that distinctive receding hairline. Only Mr. Bundy can have that hairline. Everyone's problem is that they can't admit that the man that committed these crimes is still on the streets. It's easier to say it's Mr. Bundy than to admit that the police have made a mistake. Now, Gage and Palumbo, I think they could appropriately be characterized as a bunch of space cadets. They don't remember what it was they were supposed to remember, when they were supposed to remember it, or when they said what to anybody about what they said or were supposed to have seen. First, they give a statement February 23rd to George Brand. At that time, they saw Mr. Bundy inside the Oaks on that morning. You know, I think in thinking about their testimony, you ought to remember what Debbie Ciccarelli said. And she's probably the most accurate witness in the regard that she said, prosecution asked her, "Do you remember the night of January 15th? She said, "Well, not as well as I'd like to." And I think that's what's happened with Gage and Palumbo. Not as well as they'd like to, and they remembered it quite differently on several different occasions. In the statement to Brand, they say that they're in Masterton's room when these comments are made about a professional person being long gone. But we brought in Masterton to tell you that it was he that made those statements. He was the one that said it must have been a professional. They can't even remember who was present when it was said. To even more corroborate, they're confused, that they're mixed up, that they don't remember when it is that they're trying to remember what they're trying to remember. We brought in Mr. Muller, who took the stand, said he knows Gage and that he saw him walking on Tharp Street towards Debbie Pishnanoff's party that night. And that he saw Gage at the party that night. Wooten, he doesn't remember the incident, but his official police report was admitted into evidence that he stopped Mr. Gage on Ivy Way, where Mr. Gage said he had been stopped, on the 20th of January. And then Mr. Gage said he was walking in front of the Chi Omega house. He didn't mention beer. He didn't mention Palumbo. He didn't mention citing Bundy. The only conclusion is that Gage and Palumbo are mistaken about which night they saw Mr. Bundy in front of the Oaks, and about which day they had that conversation, as well as they're mistaken about who it was that said those things. Now, the state would have you believe that it's circumstantial evidence that's consistent with guilt, but not consistent with innocence, regarding Mr. Bundy running from Officer Dawes when he was stopped by the green Toyota on February 11th, and running from Officer Lee when he was stopped in the orange Volkswagen on February 15th. The one instruction that the judge will give you, well, one of the instructions the judge will give you, is if there are two interpretations to the evidence, one indicating innocence and the other indicating guilt, then you have to accept the interpretation that indicates innocence. Circumstantial evidence that Mr. Bundy ran from those two officers is also consistent with innocence. There are lots of reasons that a person might run from the cops. A person might not want to be stopped and questioned and inquired into as to where they're going and what's your business and what are you doing, just because the cops think they have the authority to stop you and ask you what you're doing. One reason, she might be afraid that you'd be railroaded. You might be afraid you'd be charged with something you didn't do.
Objection.
There are reasons that are consistent with innocence. If the state's circumstantial evidence doesn't preclude innocence, then you have to accept the interpretation of innocence. As to Officer Dickey, 13 months later, he writes a report saying that he saw Mr. Bundy on the night of February 10th, 1978. Right about February 4th, 1979, he gets around to writing it down so people would know what he saw. I don't think I have to say too much more about that. That isn't reasonable. As far as Mr. Bundy leaving Tallahassee, the judge is going to give you instructions on several lesser included offenses in this case, which you're to consider, along with the evidence in this case. And one of the lesser included is not rent evasion. It's clear that Mr. Bundy left town because he was out of money. And this is consistent. Mr. Bundy's activities are consistent with him leaving town because he was out of money and he was running out on the rent. The state gets up here and talks to you about all their circumstantial evidence and why did he do this and why did he do that. That's a doubt as to the circumstance itself. The circumstance itself as to Mr. Bundy ran or Mr. Bundy left, the very argument of why shows that the circumstance itself is not proved beyond a reasonable doubt. It also shows that the circumstance itself is capable of more than one interpretation. And if it's consistent with innocence, then you must give my client, Ted Bundy, the benefit of the doubt and take that interpretation. State's next evidence, or the only other evidence, is their dental evidence. Before you first buy the state's dental evidence, you first have to buy their underlying theory beyond and to the exclusion of every reasonable doubt. And that is that Mr. Bundy has such unusual teeth, such an unusual formation of crowded lower front teeth, that no one else could have left that business. Now that was the conclusion of Sue, Ron, and Levine. Both of them admitted that they had no scientific data to back up those opinions. They talk about the peaks and valleys in Mr. Bundy's teeth. But if the bruise mark doesn't match a particular point on Mr. Bundy's teeth, what do they call it? A explainable inconsistency? Explainable inconsistency. It doesn't matter. We can make it fit. We just rotate it around a little bit. Well, we can't match up any of these top rings with any of these bottom rings. They're off center. So they explain the rotating mouth. Oh well. Take the picture that Dr. DeVore showed you. As to each one of the rings on the lower bite mark, using simple geometry, found the midline, the middle point of the bottom teeth. And logically, top teeth, the midline of the top teeth, fit right over where the midline of the bottom teeth are located. And where are those three scratch marks off to the left? The state's dental experts are said by the two front teeth of Mr. Bundy with the chips. They're way out of line. Oh, that doesn't matter. Doesn't matter, they say. We have an explanation for that. Either he rotated his mouth, or there are 5 separate bites, none of which go together, the tops and the bottoms. 5 separate ones made differently, independently. That's not logical. Another explanation I give you is the 2 dots on the right part of the bruise. They say that's being made by a tooth that has 1 high point. But then when you have similar dots on the left side of the bruise, they say, oh, well, that's been made by a tooth that has 2 high points. They're doing their examination backwards. They're looking at the bite mark. They're explaining the bite mark by what they find in Mr. Bundy's teeth. They can't look at the bruise mark and say, well, specifically, I can describe the characteristics of the tooth that must have made that mark. They don't do that. They do it backwards. They look at Mr. Bundy's teeth, and then they fit it to the bite mark. The state has brought into court absolutely no scientific data on the common occurrence of particular patterns of teeth. The state has not shown any facts on which these experts base their opinions. The experts themselves have admitted that there are no objective standards for their comparisons.